So Diana, let's talk about a date gone wrong.
Well, it's all fun and games till someone loses an apartment.
That's right. Why don't you lead us into this one? Because this is a recent case.
Yeah.
After cross-examination, Crown conceded acquittal.
Yeah. And so I know it was very good, actually. It was very intriguing. And so that's one of the things we'll get to in terms of what was actually going on in the situation.
Yeah.
But it was essentially a situation in which two people met at a bar and
They weren't complete strangers. They knew each other. They had met a week
somewhat
before
knew each other,
or whatever.
yeah. And ended up going home together, and then their stories greatly diverged in terms of what happened. But the main issues at trial was an obvious overstatement by the complainant about the level of intoxication. How intoxicated was she, Joseph, according to her?
She was comatose, or basically catatonic. I couldn't move my arms, my legs. I couldn't speak. I could barely open my eyes. I was basically a puppet.
Yeah. Could hear a little bit and could sort of
Maybe
semi-open
hear.
the eyes. Just in order to make it...
Just enough to make a claim of sexual assault.
So that she could say that she was aware somewhat of what was going on, although not really.
Yeah.
And this state of catatonic condition started at the bar, right? So allegedly this person was carried from the bar and shoved into an Uber, well catatonic, transported to one location,
up to the 23rd
hauled
floor.
out of the Uber, catatonic, taken to up to an apartment, then taken back to another
23rd
Uber.
floor.
Yeah, and then taken to another Uber, catatonic, shoved into the Uber somehow, hauled out of the
Downstairs.
Uber,
Yeah.
taken
out of
to
the
her,
Uber. Yeah.
taken to her own home, and still catatonically dragged into her home, which raises a few questions.
Downstairs into her basement apartment.
Right, and it raises a few questions that we'll get to. One is, how did the guy know her address? How did the guy, how did the guy get any information, and how did she get his WeChat later on? So we'll get to those. But there was a major overstatement of her level of intoxication, which became pretty clear, and in part because she admitted to having a full-on conversation with a friend.
Yeah, and the complainant had forgotten. So this was interesting. So this allegedly happens, let's say in July for argument's sake, and she goes to the police in November. So there's some months in between, or it may have been August. I can't remember the exact date, but something like that. And when she goes to the police, she walks into a police station and has an initial conversation with an officer who's extremely diligent and makes excellent notes and types out simultaneously a very detailed occurrence report of this conversation she had with the complainant. And the complainant forgets all about this.
Mm-hmm.
Gives a statement a couple hours later on video, which is at odds with the interview with the initial officer, which basically both Crown and everybody fucking ignores, but not us.
Right.
Okay.
So the original statement was...
The original statement was, I'm at the bar, I'm playing drinking games with the accused, and we're hanging out, but I didn't drink more than I usually drink, and it didn't affect me differently than I usually am when I have that amount of alcohol.
Right.
Which then later morphs into her statement saying, I don't know how much I had a lot to drink and I couldn't move, I couldn't open my eyes, I couldn't do a thing, I'm basically catatonic or comatose. So that was like the juxtaposition of the two types of statements, but the complainant completely overdid the level of intoxication. And you were saying, as another element, the complainant in both the evidence in chief and I guess initially in cross-examination didn't say a word about a full-on conversation that she had. So this is a case review, by the way, for anybody who hasn't guessed it already now.
One of our actual cases.
Yeah, so what was that conversation? Because I crossed on it, and it was not mentioned at all by her in chief, and we got her on it.
Yeah, the female friend of hers that she was at the bar with, one of the female friends at least, had offered to take her back to the female friend's house. And there was like, no, I can't go with you, I can't go with you. And she chose to go with the accused person, our client, and then completely denied that she was capable of conversation whatsoever.
Yeah, so like just to add a little bit more meat to the bones on this one, the friend talks to her. Mm-hmm. So do you want to come back to my place maybe? Because you live kind of far away. Why don't you come to my place? You can hang out there and sleep over. And complainant completely rejects that argument, says, no, I don't want to go. I have this fictitious friend at my
didn't mention that because
waiting
it's
outside my apartment from like maybe 11 p.m. and this is like 4 a.m. in the morning, waiting for me, and I have to go let her in because she has nowhere else to sleep.
Yeah. So we have that later. That's why I didn't mention.
But I know, but it's like,
go straight to.
But there's this full-on conversation. This fictitious friend plays a factor in it as to why she can't go to the friend's house, and she completely rejects it. And everybody around this conversation completely understands what she's saying, and they're communicating, and she's making a conscious decision not to go to her friend's house.
And there's a group meeting
while she's comatose.
And there's a group meeting of all the people there about what to do about this, and then they all kind of decide, okay, well, he says he lives nearby, he can deal with it, right? But the fictitious friend, let's just jump to that one because, it kind of ties into this moment at the beginning. And so the concept is that the complainant is just like going, no, focus, must get home because this friend is waiting for me at home. No clue what time of day it is. They didn't leave. We had the Uber date time stamps.
We had the Uber receipts from our client.
So the Uber receipts show that didn't leave the bar until 4 a.m. Right? And so what? There's supposed to be this friend sitting outside her basement apartment just waiting for her to show up. No idea. No attempt to contact this person while at the bar. No attempt to say, hey, why don't you join me at the bar? Or, hey, I'm at a bar, but I'm going to be home at such and such a time. And then actually leaves without the phone.
It was just bullshit.
The complainant has
it
no
was
phone
a complete fictitious lie. It was just unbelievable. So I asked the complainant, okay, so what time? Just, again, I've said in other episodes, sometimes I just have to ask open-ended questions because it's just so much fun. What time did you get to the bar? Oh, I don't know. I don't know, 11. I don't know. You know what time you left. Here's the Uber receipt, 4 a.m. So between those 5 hours, what time was your friend supposed to be there?
Didn't know. I think
did you call? Did you message?
Something about a half hour.
Did you have an arrangement? Did you, like, what?
Yeah.
Nothing. There's just nothing.
5 hours and not a single attempt to contact this friend.
She's standing out there for 5 hours waiting to get in.
Zero concern about when she was going to get home.
It's just a lie. It's a lie.
Absolutely.
It's a complete bald-faced lie. It was used as an excuse to cover up the fact that she wanted to leave with my client.
Okay, so now here's another lie from the moment leaving the bar. There's a claim.
And I sorry, I got to say this now because I don't want to forget later. Excellent Crown attorney.
Yeah, absolutely.
Excellent Crown attorney who did a very good job in chief, and when she carefully listened to the cross-examination said, this is fucking bullshit.
Yeah. Yeah. And that, that does happen. So it's good for people to know that prosecutors are not just the devil. They actually take their job seriously.
Again, like we've said, we've had excellent experience with prosecutors. They got a job to do. They have a mandate. It's not their fault that there's these policies. Brave Crown attorney who said, no, I spoke to my deputy. I can't get beyond this. This is very bad. I do not want to see somebody get convicted of something they didn't do. So great Crown attorney. But go ahead.
And so another factor in leaving was that there was this whole sort of scenario in which her friends were supposed to have input her address into our client's phone to send her home in an Uber. And then it's alleged that he then changed the address to his own apartment, right? But there's no evidence of that other than the complainant surmising that that's what happened. Right. Yeah. And, there was no claim from her that she saw it happen. She just said, oh, people told me, which is... Or it must have happened. Right. It must have happened. I'm sure that's how it happened. So they end up going to... and by the way, we know from witness evidence that that's not true, but yeah. But the Uber doesn't go there. The address is set for his own address. And, his evidence was that he'd actually called the Uber already and said he was the first one leaving. And they all went, oh, what are we going to do with her? And then he goes, well, she can come. And she hopped into his. Plan being, get the Uber driver to then take her to the next location. But she was so drunk, the Uber driver didn't want to take her to the next location. So they end up at his place. The Uber driver did not want to take responsibility for somebody who was drunk and might throw up in his car. So he was concerned. Like she was intoxicated, but she looked nauseous. Yeah. So our client had said this, and then frankly, the complainant agreed. She looked nauseous. Yeah. So it wasn't so much that they're falling over drunk, that they looked like they were going to throw up, and the Uber driver said, like, not in my car. When you put to her, did the Uber driver say that he wouldn't take you further? She said, might have. Yeah. Because you looked like you were going to throw up in the car. Yeah, she was like, I think maybe so, yeah. So then the question is,
Where did the Uber driver pick them up?
a block and a half away from the bar they were at. She had to walk with our client to
Finally, in cross-examination,
pickup
she
point.
agreed that she got up and walked, linked his arm, and walked a block and a half away to meet the Uber driver.
But only because we had the Uber pickup point, which she agreed was a block and a half away from the bar.
Yep.
Otherwise, she might not have agreed to it.
Correct. I mean,
She's
that's
just
why
stuck
these
with it.
documents are important.
I know. But then ultimately they end up leaving his place and going to her place. And then the question becomes, well, how did he get your address at 5 a.m?
Correct. I kept asking that.
Yeah, and that was a big thing. It was like, even if he did originally have your address, changed it, he wouldn't still have your address.
It's not saved unless you order it.
But she refused
cancel
to
it.
admit that she was conscious enough to actually give her address at the beginning. She couldn't explain how he got her address.
She totally resisted that at any point she gave the address, completely resisted it. I took her to her initial statement where she said, I woke up at hour, I told him to take me home. And I then furthered that by going, and that's when you actually went to his phone and you typed in your address into the Uber app to order the Uber.
Right.
I don't remember. Maybe. I might have.
Yeah.
That's already when somebody's caught and they're just like trying to deny, but they know that I have the goods on them. So they're trying to soft pedal it.
And now then people may wonder, why did he bother going with her once he finally sent her home? And that's because
That was obvious.
She didn't have a phone, so it wasn't safe for her to
Her
go.
friend kept her f***ing cell phone. Not sure why.
Right.
She didn't have her cell phone. And our client said, well, I didn't want to take a chance that something happens to her on the way home. She can't get into her apartment. Like, I don't want that to happen.
Call for help or anything like that. So yeah, it was a safety thing.
And she claimed in her evidence that while at our client's apartment, he had sexually assaulted her over and over and over and over. And we had the Uber receipts. They were at our client's apartment for 59 minutes.
Right. Yeah.
Of which they slept.
And they had to go up to the 23rd floor and then back down from the 23rd floor and really his battery had died and he just had to charge it and they fell asleep for a bit.
Right.
And so here's where things started to go really poorly for her. There were messages exchanged between the two of them because he ended up staying for 3.5 or so hours.
Yeah, just go explain it and then I'm going to say something.
Okay.
Yeah.
And so then when he's leaving in the morning, calls an Uber, goes out by himself, and there's a confrontation with her landlord. And he just says, yeah, okay, sorry, my Uber's here, whatever. Gets in, goes home. While he's still in the Uber, 5 minutes later, all of a sudden frantic messages start. But the complainant did not give all the messages to the police.
Yeah, so let's give the context. So frantic messages start where the complainant is saying, I'm going to get evicted because so this is not something you could normally happen, but she was a student in somebody's basement and they want to kick her out because they don't allow any guests. Okay? So she's saying, I'm kicking you out. This is not the place for you to stay. So she's frantically messaging our client, and then our client, there's a guest fee, so he sends $30 by e-transfer. Here's the guest fee. She's not, so, well, give me some money so maybe to compensate her for frustration, sends over $100 by e-transfer, and there's that conversation. And I start cross-examining the complainant about messaging. It starts, literally, he's in the car no less than 5 minutes.
Mm-hmm. And then one more thing, too, is like, I got to get my phone back. Can you get me an Uber? So there was like 2 e-transfers and an Uber.
And then he winds up ordering an Uber later on in the morning so that she can go to her friends to get the phone. Mm-hmm. So she's really manipulating him and using him because he's now feeling bad that she might get evicted, okay? So I start cross-examining and I go, so you were blaming him, you were angry at him, and your anger kept increasing, that it was my client's fault that you're now being evicted. And eventually she had no choice but to agree. Yes, I was expressing anger. I was angry at him. I was telling him it's your fault. I said, you started to say to him, you took advantage of me. Now I'm the one going to lose my home. All that stuff. Okay. And this is a lot of messaging.
Yeah. And which, as a reminder, I'm sorry, you didn't tell your landlord that this fake friend was going to be staying over?
Good point. Good point. So this comes out in cross-examination because she thinks I have the messaging. Okay. And I'm holding some paper, but I don't have the messages. I have the transfers. We have the e-transfers. So we know what our client is telling us is the truth, and we're pinning her down at that point with the the transfers, so she thinks we have the messages. Now, in the police interview, the complainant shows the officer messages on WeChat, which is an app which is commonly used in the Asian Chinese community. And, you know, if you delete it, it's gone. Anyway, she saved certain messages.
She only provided certain messages. I don't know if she saved them all, but she only provided certain
Only
ones.
certain messages provided, and of course, please provide me with the messages that you want me to have, okay?
Right.
So she selected what messages she wanted to turn over. And I went at her for a good part of cross-examination.
Those messages only start at the point where she starts making accusations.
12, and that's about 3 hours or 2.5 hours later, after she's already admitted now to me that she increasingly got more and more and more and more angry with him, that he is responsible for her losing her home. And she is fucking losing her shit. And she asked for $300 she starts to blame him, to say, you had sex with me, you didn't use a condom, give me $300 for an examination and for the morning after pill. And she says, I went for an examination, I catch her, she didn't go for an examination. But what was most important here was I got her to say, you decided, you made an intentional decision not to provide to the police officer any of the messaging between 9:36 a.m. and 12:05 p.m. Mm-hmm. Not one of them.
Right. And in her testimony...
You didn't even show them or mention them to the police officer.
And in her testimony in chief, like before cross-examination, never mentioned a word about the landlord being evicted, nothing, right? This massive gap in the storyline, and just made it sound like I was so disoriented, I don't even know when I woke up, and I just looked to see if there's a condom, and I don't think he used one, and then I was just so upset I started sending these messages. That's the narrative that went in.
And I was trying to be polite, because I don't know what he could do. He could kill me. He could kill me, because I have to say this. In Taiwan, people die all the time.
That was the claim.
Now, if you just fucking look up the crime rate in Taiwan, it's like the third most safest country in this planet. Singapore, I think, is number one.
Up there anyway.
Like, I think it's 173 homicides across the country per year, in any event.
But you skipped over the $300. Okay, this is one of my...
Yeah, you expand on that.
This is one of the good moments. So there was a $300 e-transfer, which she did admit to.
Finally,
and, yeah.
So we had the receipt.
And she provided that one, only that one, to the police. You know, her messages had in there where she's asking him for $300, and he says, "Did you get it?" But he was like, "I was sleeping," and you know, we'll get
and
to
says sorry.
His responses, but you actually asked an open-ended question at one point, which you don't usually do. But you're just like,
no, I do more now because it's so much fun.
It is fun. Is that so? What did you do with the $300?
Yes.
And she's like, I went to Women's Hospital. And I
had an examination
and bought the medication. And then in her police transcript...
No, but then I go, okay, so did you turn over the records? Like, did you sign the release for the records of the examination? No.
But then also, you take her right to her police statement in which she directly tells the police, I did not go to the hospital because I didn't have a health card for Ontario.
I only went today.
Yeah.
I went...
The same day as the statement,
this is
months later.
Yeah, so...
It was a direct lie.
This is 3 months later. The day that she's going to give the statement, she goes to the hospital, reports a sex assault and does an examination, which is completely useless as a setup for her statement to police. Right. And then walks into 52 Division.
And outright lied when asked, what did you do when he gave you the $300? Oh, I went to the hospital.
Like I'm some f***ing idiot. Like I can't read... Like, I didn't watch your video and transcribe it. Here's your transcript of your statement. Like, sometimes they think we're morons, right? Like...
And then, okay, the icing on the cake, I guess, too, was 3 days before trial. All of a sudden, she says, I have a new witness.
Oh, yeah, that was a good one.
And they're like, what? Okay.
Okay, we got to talk about this, because this is a good one.
So we're told 3 days before trial... Oh, she's provided the contact information for a new witness. And then, so we get
And the police are diligent. They interview them right away.
Yeah.
They upload it. We get the audio, and we get a summary of it.
Yeah. And so we listened to the audio, and this person had no clue what they were talking
about. It wasn't enough time for us to do what we normally do, because we take all statements, we transcribe them, but we had to go basically on reviewing it and then just having a summary. But go ahead.
Right. And so we didn't know for sure because there was another person who was present at the bar who was potentially going to be a witness. We didn't know for sure if they were going to be called. And so this new witness suddenly shows up and wanders into up to the room we were sitting in.
We're in court. Okay, so we're at the courthouse and we're in an interview room. So this witness, go ahead, just wanders into our room.
And you already looked annoyed. And you're like, who are you? What do you want? And he goes, I'm the defense lawyer.
I'm normally polite. So
then,
just don't think I'm a dick all the time.
But it's just like,
I'm not.
You know, this guy was just, but it was because he was standing there going, like looking totally lost, right? And they're like, what are you here for? And then he goes, well, I don't know if you want to talk to me. And then you're just like, all right.
Okay, I'll talk to you.
And you asked him like 3 questions, basically. 1, how long have you known the complainant? And it was just kind of like silence.
Did this. Is this really? Because that's when I started to become a real dick. Sorry, is this a really hard question?
Yeah.
How long have you known the complainant?
Yeah.
2 years.
When did she ask you?
Well, hold on. When did this alleged offense that you were part of giving evidence about happen?
Yeah.
How hard is that? Where were you? When did this allegedly happen? So it's actually 3 years ago, and he just became friends with her 2 years ago.
Right. And you're just like, when did the complainant ask you to say that you witnessed this? That's right. And then he was still stuttering, and he was like, these are not difficult questions. Why can't you answer them? And it was just done. It was just like, you're like, okay, I'm done with it.
No, it was, and normally I'm not like this, but I know he's lying. I know it was manufactured evidence. Yes. I know she asked this guy to do it. And then he admitted that like I said, like, she contacted you to do this, correct? Yes. And when did you last speak to her? And when did she just last tell you about what to say? Well, on Thursday.
Right.
Okay. So I'm livid. And I tell the Crown, God bless the Crown attorney. She says, I'm not calling him. Yeah. He goes down to the 7th floor where the victim witness office is, because in this case, the complainant was testifying by CCTV. And we'll talk about that in a moment or two. But we don't normally consent to it. But in this case, our client actually wanted that because he was very affected by this, like extremely traumatized to the point he had serious mental health issues, okay? Yeah. And we were concerned for his well-being. So this witness is now hanging around, waiting for her to come out to speak to her about what I obviously grilled him about, okay? And the Crown sees him and says, get out of the building. Get out with the cop. Get out of the building. Good Crown attorney, right?
Oh, yeah. Yeah.
Okay, go ahead.
No, I'm glad that she could see right through it.
Yeah, she's, well. You know, like, smart, intuitive. She's going to be a very good Crown in years to come. Very, very good.
So you mentioned CCTV, and that's a situation. It can happen in a few different ways, but usually the person has to go to the courthouse and testify in a secure environment, in a proper courthouse environment, but in a different room and somewhat away from the trial, the courtroom.
Yeah, so we don't,
interact.
Yeah, so we've talked about CCTV. So it's now that all the craze to have complainants testify, not in the courtroom, but by closed circuit TV. We oppose it all the time because we think it's much better to have them in the courtroom. That said, cross-examination still goes effective through the TV screen. That said, we do not want them testifying from home.
Right.
And the Crown was great about this as well. The Crown said, no. She's going to have to come in to a specific room in the courthouse and be in that room to testify.
Well, and one of the issues too is that, especially in this case, there weren't too many, but you can have documents that you need to put to them. Yeah. And in this case, we had to have little envelopes with numbers on them so that she couldn't actually sit there and go through them on breaks and stuff like that. So it becomes more complicated to share the documents and have them review them and stuff. So there's other reasons other than just, your right to face the accuser. Not so much anymore. But in this case,
I still think there's value to it, but it hasn't harmed us at all.
Yeah, but in this case, leading up to trial, our client expressed extreme anxiety, saying, is she going to be there? Is she going to be there? It's like he was terrified about his anxiety attacks if he had to actually look at this person who put him through this in his life and was worried about testifying with the person sitting there. So when we were asked for CCTV, it was like, that would actually help our guy out a lot.
Yeah, no, and we have to say this because we've spoken about this on a previous episode where we had, our colleague come. This particular client who's young, who's 25, was so incredibly impacted. And I'm amazed sometimes at many of our clients who are much more stable. He was broken and very vulnerable, to the point that he was under care. And he was very nervous about being able to give his evidence if he had to testify with her there. So when the CCTV application was brought, I thought, you know what, on balance, it'll be better for our client. The Crown seems to think there's some value to it for the complainant, whatever. But sometimes it is of value when you have a client who's so vulnerable this way that just seeing the person was traumatizing.
And I think that's important to mention too, because people often forget what an accused person goes through. But
all the time.
And it's always just, victim, victim, victim. It was like, they're not victims, they're complainants. And think about, this person whose whole life is in front of them.
And we talk about this often because we have, again, people like, our practice is busy and we only take on a certain amount of clients per year because we don't run, a volume practice. We want to be able to devote all the time necessary to successfully defend a client. But there is a ripeness to a file where a client has to get into the right psychological mindset to testify, and that takes time.
Yeah, it really does.
It can't be done immediately. People think, and I know people are like, I want this over with. I can't handle it. But the problem is they are not in the right emotional, psychological state to actually go through a trial and be an effective defense witness.
Right.
I can't express how important that is to realize that in order to be able to defend yourself, you have to be in a much better mental state.
And that kind of ties in as well in terms of mental state a little bit to an interesting issue that came up in this one as well. We mentioned that there were these allegations as he started getting barraged after a few hours went by, and all of a sudden these crazy messages are coming into him saying, I feel like you did this, I feel this way, I feel like I was a puppet, and now you owe me $300 I need $300 from you for this. That at no point did he did say sorry in the end, only because it took him a while to get the messages and send the $300, but he never countered those messages saying, I didn't do that. He never said that. And so then that can sometimes they can try to present that in court as the lack of denial.
Well, they do. We did a whole podcast on can the failure to deny an allegation when it's made result in you being found guilty, and can it be used as evidence against you? And there are certain circumstances where that can be a significant issue.
And it's kind of difficult. You kind of had a note about how stressful it is for people, which you kind of covered. It's good to have that time to try and prepare yourself and stuff, but having to sit there in court and be silent and have listen to the complainant making all these allegations, which if believed could send you to jail. It's kind of terrifying for a lot of people.
It's terrifying, and you also have to remember, and this is what we say, just how we can't make submissions or ask questions about ungrounded assumptions about how a victim or a complainant would truly behave. The same goes for an accused. Right. Not all people will say the same or will result in the same behavior when confronted with an allegation. They won't all say in a message to the complainant or a phone call to go, what the f*** are you talking about? Are you out of your mind? Here's what happened. Yeah. That won't always happen. And in particular, this individual, when you ground it in his personality, his character was one who said, I didn't want to engage. I didn't want the drama. I just wanted to send her the money and just move on. I didn't want to be part of this drama. Yeah. And you could see that there was this, deer in a headlight. Is she nuts? I'm just terrified of the situation. Did not want to engage. Well, that is fair, because not all accused people will act in the same manner. There's no right or wrong way for them to behave. Right. But this is a dangerous issue, and you got to handle it properly in your defense.
Now, in this case, and this is something I wanted to talk about because it's so common, we had a situation in which he got a peace bond. Yeah. With the withdrawal from a prosecutor who just said, I'm not going to try it. It was a very, very fair prosecutor. But we had a peace bond, and then
that was in a couple of cases ago.
Yeah. Well, but that's the thing is when we have cases with John, that a peace bond is almost always involved.
Yeah.
And people get really kind of worked up and sometimes don't want to take it and don't understand what the peace bond is. In this case, like, sure, he could have gone to trial, and he, like, and the judges said in this, oh, thanks for saving me the time because I would have come to the same conclusion, kind of thing. But it doesn't make a difference to them, and it spared him from having to testify. It, resolved it. His anxiety over testifying was great. It was a perfect solution for him. But peace bonds are not any admission of anything. And
yeah, you have to be careful because in both of these cases where we had one offered, I mean, we have a lot of this, but we had one offered before trial, one at the end of cross-examination. And one, you have to remember there's no guarantees on anything. So if it's prior to trial, yes, we're creative. Yes, we're successful. Most of the time we believe in our clients and they're telling the truth. That doesn't mean you're going to succeed at trial. You still have to testify and you have to survive cross-examination, which is a stressful process. And so when you're guaranteed a withdrawal of a charge and you sign a peace bond and you specifically say on record, there's no admission of criminal or civil liability.
Well, this was actually a dismissal, a directed dismissal.
This was a dismissal, but regardless, there's no admission of criminal or civil liability. It's simply in order to have no contact. And when you put all these things on record, there's little to no effect. People, if they worry about traveling to the United States or no effect, we always tell them, let's get a certified copy of the court information, show it so that it's withdrawn. U.S. Border Authority understands this. It's not a problem. And then in the case where we got the directed verdict, it also is a situation that spared the accused from continuing to have to be cross-examined because there was risks, and as much as somebody may be telling the truth, it's still a very stressful process. So, like, the reality is Crown attorneys will often ask in cases for a peace bond just simply so the parties, there's some piece of paper that says they're not going to have contact. That's all. We're not saying this isn't some sort of we understand when a person says, well, does this mean like I'm guilty? No, but we explain it. You hear it on record. The charge was dismissed. You're not guilty. Even the judge goes, this doesn't mean you're guilty. It means you're not guilty. Charge was dismissed. You're not guilty. I'm just making an order for you not to have contact. There's no admission of any liability. The judge went through all of this, actually. Right. There's no liability. You don't have to worry about that. You're innocent. It's just so you stay apart.
Right, which generally the accused person doesn't want to see them anymore either.
Yeah, and so like when you're in instances like this, because there's some people who say, I want to go to trial. I'm like, okay, well, no problem. But remember, when you get a guaranteed dismissal or a guaranteed withdrawal, it's something that's hard to give up.
It is really common that judges, sometimes they'll say that I probably would have come to the same conclusion. They usually say probably, but they also make a point of saying they found the complainant very credible.
Yeah, now, let's just say this in closing. So before a trial happens, we've had a couple of cases where we know the evidence isn't going to be pleasant for both sides, right?
Right.
So we say to a client, do you really want a written record of all this? Because there will be a transcript. And this typically happens in domestic cases where there's a family court proceeding. And I say to the client, I know what your evidence is going to be because we've prepped you and we've worked through this. Mm-hmm. I know what her evidence is going to be. I know what cross-examination is going to be. But you know what's going to be on record. Mm-hmm. You know what you're going to have to say in testimony. Do you want this on a record? Do you really want this on a transcript that either party can then use?
Yeah.
Or would you just rather have charges withdrawn, peace bond entered on a with or without, like there's no liability, without prejudice basis, gone.
Right. And then move on with your life.
Correct. All right.
You shall move on with our night.
Yes, we've got a whole bunch of more trials and more episodes to come. So don't forget to like, comment, subscribe, share. Again, as we always say, please keep sending us these comments and emails. There's great ideas that come to us which really help us, and we answer questions. So we're delighted to continue to have all of your input. So thank you very much. Have a good night, and thank you for your viewership.